Hello, everyone. Thank you for sticking around for that little bit of an extended start to the podcast. For those of you who don't know, my name is Just Jonda. I am an attorney, podcaster, your girl Friday, especially when it comes to these cases that we love so much. So, we are going to jump right in with part two of the Diddy indictment. And I am calling this part two, no bond, because that is what happened today. We saw the beginning of this bond showdown yesterday when the court entertained the beginning of what we knew was going to be a much longer situation when it came to the question of will he or won't he get bond. So let's get right into it. I'm going to pull up the official court documents just like we did yesterday so that I can talk you through them, give you the benefit of my many, many years, too many to name, it ages me, expertise as it relates to the bond situation. For those who are watching on YouTube, playing with the lighting a bit here. We'll get it right eventually. Okay, I think, nope, I changed it. We don't want to be blue. Okay, there we are. All right, so let's jump right in. I'm going to put my screen into presentation mode so that you all can see. Those who are listening on the podcast, we are getting right to the documents. As I pull that up, let me just give you a brief recap, and I'm also going to give you a bit of a primer on how the bond process works and the things that the court has to consider. Because as we know, I like for those of you who hang with me to be the smartest folks out there. So when you're around the water cooler and you're having these conversations, you actually know what you're talking about. And most importantly, you got it from someone who knows what she's talking about. Okay, so let me pull up the document. So the first document that we're going to get into here, we're going into Windows. We're going to entire screen, Chrome tab. All right. Okay, there we go. All right. So the first document we're going to get into, and then we're going to circle back and talk about what's important in all of these. So the first thing we're going to talk about is what was at stake. What was it exactly that Sean Combs, Diddy, Love, Puffy, for the purposes here, we're going to call him Sean Combs. So I may slip into Diddy here or there, but we're not friends. We're going to just call him Sean Combs. So the first document we're going to get into after I explain the bond process is the document filed by Sean Combs' attorney, who at the moment is a Mr. Agnifilio. Yesterday, we heard about this tremendous bond package, this bond package that was offered by Mr. Combs' attorney, Mr. Agnifilio. And these are the things that he offered. And again, when I explained fully the bond process, you'll understand why. For those who are coming into the comments, feel free to comment. Also, feel free to ask questions because I'm definitely going to be keeping an eye on the chat so that I can answer your questions. Okay, So this is the proposed package because this is what came up yesterday. And I'm going to try and take us through this chronologically. Yesterday, what Sean Combs's attorney proposed in anticipation of the fact that the prosecution, or as we call them, the AUSA, the Assistant United States Attorney, in anticipation that the AUSA was not going to be in favor of bond for a number of reasons, which we'll get into in a moment, they came up with this huge bond package hoping to sway the court. So this is what was on the table. The defense proposed the following: a $50 million, that's million, lot of zeros there, a $50 million bond that would be co-signed by Combs's mother, his sister, the mother of his oldest daughter, and the mother of his youngest daughter, as well as his 3 adult sons, who we know a lot of their money is linked to him anyway. But the bottom line is all of these individuals were going to co-sign. Now, that bond was going to be secured by property, because you can't just say, oh, these people have the money. No, how are you really going to lock that down? So we're going to secure it with a home with an appraised value of $48 million, which is his Star Island home in Miami. $48 million, I'm sorry, which is the Star Island home in Miami, Florida. The house, they claim, is unencumbered. As of August of 2024, it had $18 million left to be paid on the mortgage. He paid that off because, again, they knew these charges were coming. So there's a piece of property worth almost $50 million that is unencumbered. Also, the equity in Mr. Combs's mother's home in Florida doesn't say how much the value is, but when you consider that the Star Island home is almost to that value, that's just tossing in the extra couple mil. His travel would be restricted to the Southern District of Florida and the Southern District of New York to attend court, meet with his counsel, attend medical appointments, as well as the Eastern District of New York or the District of New Jersey, only to the extent that his travel to and from New York involves an airport in those districts. So essentially saying, I may fly into Jersey, I may fly into Newark, as opposed to LaGuardia or JFK. I'm assuming that's what he's saying. He doesn't say anything about having a home there, and apparently hoping to stay in the Miami home part-time, since he's asking to go back and forth to Florida. He would surrender his passport, which, according to what was submitted by attorney Agnifilio, he surrendered his passport to him back in April, back when the house was raided. The house was raided, or his houses were raided, around the end of March. So on April 1st, he gave those to his counsel, and the counsel can provide those to pretrial services. In addition, he is proposing the surrender, and this is key. I got asked a lot about this between personal friends, the other website, and another show that I did last night. This has been a question on a lot of people's minds. Why would a person propose surrendering the passports of, in this case, his mother and his daughter? So we're talking Janice Combs, Chance Combs, Jesse Combs, Delilah Combs, and Love Combs, who are his children or the girls. My quick and dirty answer to this is that, as we know, at least as it relates to Jesse and Delilah, he has had custody of them since the death of their mother. As it relates to his mother, I believe sometimes, according to my personal sources, lives with him some of the time. And of course, the other minor children, as their parent, he would also have access to their passports. So my thought process with this, especially if I were representing him and proposing this, would be that you want to give the court as many good faith assurances as possible that not only are you not going to use your own passport, because that's been surrendered, but any passport that you would have unfettered access to. People ask, why not the sons? Why is it just the daughters? Well, all three of his sons are grown. So those individuals arguably would have not only have control over their own passports, not that you couldn't borrow it, but those are individuals who would be like, hey, I want to be able to come and go for what may be the next 2 years between the time it's going to take for this case to work its way to trial and actually be tried, should a trial actually occur. Because if this case goes to trial, if there's not some kind of plea in advance, or the charges dropped for some, for some reason or another, this will be a long process. So you're talking about the possibility of saying, hey, I'm going to surrender my passport for the next couple of years. Well, they're adults, and quite wealthy adults if they have access to dad's money in any way, or have had access, or trust funds. And of course, as we know, at least one of them, well, possibly even two, have worked fairly consistently in the entertainment industry as well. So these are young men who are used to coming and going as they please. So that is what I would suggest is the reason why the girls and not the boys. Since at least April 2024, according to his attorney, he's also been making efforts to sell his plane. And there's a letter of intent with a party to sell it. Just according to his counsel from just last weekend. We know that something like a plane is probably not easy to sell. But either way, the plane is grounded. It's not being moved from its current location, certainly not by Mr. Combs, according to his counsel. Home detention with GPS monitoring, that's a given, and restrict all visitors to his home except for family, the property caretakers, and friends who are not considered co-conspirators. So basically, anybody can come and visit me as long as they're not considered to be a part of my criminal enterprise. Restrict female visitors to his home except for family or the mothers of his children. I'm not even going to go any deeper than that. That's what they said, and we're just going to leave it at that. The security company that secures his person and properties will require any person to sign a visitor log, and those logs would be produced to pretrial services. Again, if they say so, we're going to go with it. No contact with known grand jury witnesses, because we know that there were many. We don't know who they are, but there were a lot of people who were interviewed, and I suspect a good number of them did end up in front of the grand jury. As we're finding out, over 300 subpoenas, or at least requests for interview, were sent, and at least 50 were interviewed in some way, and some, of course, were involved in the grand jury proceedings. Weekly drug testing by pretrial services, and all other standard conditions of pretrial supervision. So they tried to basically cover everything. So before we get into the prosecution's memorandum, I think what would be really important here, I'm going to pull up the prosecution's memoranda, and then we will come to this. Okay, so there we go. And before we get into the prosecution's first memoranda, because they submitted another one that got even more spicy, and we're going to go through these because the memoranda that the prosecution submitted, the detention memo, essentially, that the prosecution submitted, went way deeper than the indictments, which, as I explained to you yesterday, are merely just to inform the individuals of what they're charged with. Some offices spell these indictments out a lot more than others, but they really don't have to. That is a point that keeps coming up again and again, no matter what show I watch or appear on or have given input to. Shout out to some of my favorite YouTubers, by the way. Nikki Starr, I had a great time contributing on your show yesterday. And of course, Really BTV, again, had a great time contributing on your show as well. Both of those shows, I will put the links in the comments after I finish this. Great. They do not own, a lot of them do pop culture, which of course, I love as well, if you listen to me for any period of time, but they also step outside of their pop culture bag and take cases seriously as well. And when they do, they make sure to get expert opinions, which is what I love about them. But I also love that they have a lot of fun doing pop culture and all the TV shows that I like. And again, if you listen to me long enough, I like all of that messy stuff, and I like to get into it and put a legal spin on it if I can. Okay, so bond standards, because this is going to be really important as we go through what the court considered in these hearings. So these are the factors that a judge considers when determining bond. So, and the federal factors in this case are very similar to the factors in the state that I primarily practice in. So this is, again, something that I fully have to deal with my own criminal clients, criminal defense clients. Okay, the nature and circumstances of the offense. Now, this is important for a couple of different reasons. One, what is the person? So the obvious one is, what is the person accused of doing and how serious is that offense, right? Because not every offense is created equal. So we could be, on the one hand, talking about someone who is charged with a simple assault. There's nothing extra about it, no sexual. And again, it's YouTube. That's why I'm saying certain words that way. There's nothing extra egregious about it. I mean, and he slapped somebody around. It's an assault. It's still a problem. But again, there is still a far cry from someone being charged with a simple assault, maybe something that arose during a domestic disturbance, or, young people going back and forth, versus someone being charged with manslaughter, or, and of course the million things in between. Far cry with somebody being charged with driving under the influence versus somebody who commits vehicular manslaughter because they were not only driving under the influence, but they hit someone and that person lost their life. So again, we look at the nature and circumstances of the offense, because simple offenses, the court doesn't even get that deep unless turns up the person in front of them has warrants or an extensive criminal record. But if you get picked up for driving on a suspended license, you're probably going to get bond and go home, absent some other extraordinary circumstances. Okay. However, that nature and circumstances, there's another piece to that as well. So there is the surface level of how serious is it, right? But then there is an actual legal piece that that comes into play that goes beyond just the common sense of, getting picked up for a suspended license is a lot less serious than hitting someone with the car while you're driving with suspended license. It goes deeper than that. And that is that there are certain categories of offenses where there is a presumption against bond. So what does a presumption against bond, or any legal presumption, means? That means that literally written into the statute, it says this charge, this charge, this charge, and this charge, no bond unless you can present evidence that beats that presumption. That is an important factor in this case because the offenses that Combs is charged with, the conspiracy racketeering, the SX trafficking, and the transporting charge for maybe not the transporting charge, but certainly the first two, those charges fall into that list of enumerated offenses that says no bond, presumption against bond, which means that you're already starting to push that boulder up a very steep hill because the judge is already starting from the standpoint of no, not maybe, not, well, will I or won't I? If there is a presumption against bond, the court is already starting at no. And you have to convince the court as to why no should be backed away from. So now we get into the other factors. Now, again, all of these factors are weighed in any case, but again, in a presumption case where there's a presumption against bond, you have got to pump up these other factors. Now, the problem is in this case, which we're going to see in a little bit, there are some hits against some of these factors that makes him having a presumption an even more heavy burden for his attorneys to shoulder. Okay, so what's the weight of the evidence? So this is where the prosecution actually starts to talk to the court a little bit about the evidence in the case. So they won't go give away everything, right? This is the bond hearing. You're not giving away the full kitchen sink, but you will talk about some of the evidence in the case. I got to move my mic a little bit closer. I'm getting some. I hope there's no issues with you all hearing me. Okay, so what is the weight of the evidence? So we talk about it. This is where, as we go into it, then this is why the prosecution, the AUSA in this case, Damian Williams, actually got a little bit deeper about some of the things that are going to come up in this case, about some of the evidence that they feel weigh in favor of these charges. And because it gives the court a glimpse and say, even if the charges are serious, if the evidence is kind of crap, I'm still not going to hold the person, presumption or not. So you got to give the court at least a taste of what the evidence is. The defendant's criminal history, for obvious reasons. If you have been out here being a terror in these streets, then why the hell am I going to send you back out there, especially if you are charged with something else, serious or not? If you have a lengthy record, then that speaks to the fact that you, A, haven't learned a lesson, and B, that you have a propensity to reoffend. Ties to the community, that ties in very much to risk of flight, because someone who doesn't have ties to the community has less of a reason to stick around when they've got a good reason not to, specifically going to jail. Danger to the community, and the danger to yourself as well. Danger to the community, this is going to be a key factor in this case that we're going to talk about quite a bit as we go through these memos. Danger to the community, keep a big star next to that one in your mind, because that was probably, in my opinion, the single most important factor, at least in this particular case, that probably did Combs in when it comes to attempting to overcome a presumption against giving him bond in the first place. Ability to afford bail. Well, this, of course, not really an issue for someone in uh, Sean Combs' situation. But of course, when it comes to your average person, the types of people that I represent every day and others, because you just never know what people's situations are. We know folks put on a lot of fronts, and a lot of people look like they're living big, but are still one paycheck away from homeless. So the ability to afford bail is also taken into consideration. And really, part of that isn't, when they look at that, it's not just so much taken into consideration in terms of whether or not somebody should get bail, but really more so what kind of bail and conditions are you going to be putting in place? Because if they can't afford it, if you do something really outrageous, especially if it's outrageous and a bit out of line as it relates to the charge, that's essentially the same thing as giving someone no bail. Input from pretrial services. Typically, pretrial will interview the individuals and literally go through all of these factors that we're talking about, but do an actual report of their own on them. I doubt that pretrial services really played a role in this case. One, things went very quickly, and two, he had a legal team that put together a package and more or less a report of their own that covered basically all the same things that pretrial would have done. So while pretrial services would have verified some of the information, the residence, the phone number, all of any reference information, yes, they would have done that. But as far as a full blown history and report, probably not so much, maybe not really necessary. It would have been more along the lines of verification. Another one that is huge in this case. So, like I said, the danger to the community, single largest factor. This is another factor that kind of goes hand in hand with this one. Public safety versus presumption of innocence. As we know, everyone is presumed innocent until you are found guilty. And that always has to be foremost in the court's mind. However, that in the bond setting is still weighed against the fact that you may or may not be a danger to the community based on all of these other things that we have talked about. And again, that factors big in this case. So danger to the community, public safety, two sides of the same coin, and then they are weighed against the fact that you are still presumed innocent. Okay, so now you've gotten your legal lesson, your bond primer. So let's get right into these memos. I am also going to check these comments because I want to make sure if there's any questions that no one is left out. Okay, so let's get into it. So this first memo that I'm going over is the memo from the Department of Justice. It's from AUSA Damian Williams, who we all met yesterday when he announced the indictments. Well, actually, we basically met him yesterday. Sean Combs was arrested on Monday night, and then Tuesday morning press conferences and the like. Okay, so let's get into it. In anticipation of Diddy's team wanting bond, because obviously they knew this man was going to want bond, they also came right out the gate with a memo that went a lot deeper than the indictments. So I'm going to skip around, but I'm going to give you the most important pieces because we're going to try not to go beyond an hour 15 tonight. Okay. The defendant, Sean Combs, aka all of these other names, was taken into custody this morning after a grand jury sitting in this district returned a 3-count indictment charging him with crimes related to his decades-long pattern of physical and sexual violence against multiple victims and his use of force, threats, and coercion to enact his will, protect his reputation, and fulfill his desires. The government submitted this in anticipation of his appearance and in support of their request that he stay detained pending trial. Again, very significant because this is not a DUI. This is not any of some of the simple things that I talked about earlier. This is a case that even in its pre-trial stages could go on for a long time, even though he's detained, even though there is a speedy trial. A lot of times the defendant themselves will waive that in favor of having more time to prepare their case, especially when there is pre-trial motions and arguments going back and forth, many of which we know are going to take place in this case. And we also know that in addition to the fact that there is going to be heavy motions practice in the beginning of this case, there is also going to be appeals of a lot of those things as the case goes on. He's got the money for a legal team that anytime there is a ruling that they don't like, just like this bond ruling, this is this bond appeal, this is just the beginning. Everything is going to be appealed in this case constantly, that if it does not go in their favor, and they have the resources and the team to do it. Welcome to the new people in the room. Please feel free to ask any questions in the chat. Okay, so let's get into deeper into this letter. So the government comes out strong with their language by saying there is no condition or combination of conditions that will reasonably assure the appearance of the defendant as required and the safety of others in the community, not to mention the integrity of the proceedings. That's a key sentence, first of all, because that's what we call an omnibus sentence. It covers everything. Just saying, yes, we saw that they are willing to give up $50 million, houses, planes, all of this other stuff that they claim that they are willing to do. And even with all of that, we don't believe that will still either A, ensure his appearance, or B, keep everyone safe. Now, if he gives up all of those things, he's under constant surveillance, people could potentially lose $50 million homes and stuff. Do I think that he would run in light of all of that? Probably not. And I think the government probably knows that as well. That's not really the big issue. The bigger issue, and we're going to see it again and again, is that safety of others and the community and the integrity of the proceedings, because both of those things hint at what is going to be discussed a lot in this situation, which is the intimidation of victims and witnesses, which undermines the case, which of course makes people feel unsafe and at risk, which many of the individuals said that they were, which is why they ignored subpoenas, as well as, of course, undermining the integrity of the proceedings, because if your witnesses are either afraid or they go missing, whether of their own accord or by other more nefarious means, well, that does undermine the case. It undermines the integrity of everything. You might as well throw it all in the trash. Okay. They also are addressing these factors that I just went over with you all a bit ago. And for those of you who are just popping in, when you have a chance, rewind. We did talk about the factors the court considers. As reflected by the gravity of the charges in the indictment, the defendant is dangerous and poses an ongoing threat to the safety of the community. If released, he remains a serious risk of flight despite the conditions offered by his counsel. Most glaringly, the defendant also poses a significant risk of obstructing justice. So again, we're talking about that whole thing with witness tampering and all of those things. Well, we'll get into the whole Kalima situation. Indeed, and as set forth during the course of the charged conduct, the defendant has attempted to bribe security staff and threatened and interfered with witnesses to his criminal conduct. He has already tried to obstruct the government's investigation of this case, repeatedly contacting victims and witnesses and feeding them false narratives of events as described in detail below. There are simply no conditions that would ensure the defendant's efforts to obstruct and tamper with witnesses will stop. The defendant therefore cannot overcome the statutory presumption in favor of detention, and the court should order him detained. And again, that's where things get really messy, because if you have witnesses who are saying, I'm talking to you because I have to, or maybe even because I want to, but at the end of the day, this mofo will not leave me alone. I am getting phone calls from him. I'm getting phone calls from people associated with him. I'm getting text messages. I'm getting all of these things. That is a substantial problem for him. It's a problem for the witnesses as well. And and of course, arguably, as far as the government is concerned, it poses a risk to public safety and, obstruction, undermining their case. Very problematic when you want bond. Huge, especially when your charges have a presumption against it in the first place. On September 17th, 2024, yesterday, an indictment was returned and it was unsealed. So we know that he was charged with racketeering, conspiracy from on or about 2008 through on or about the date of the indictment, so all the way to the present. SX trafficking from on or about 2009 through around 2018, it says in or about 2018. That's count 2. And interstate transportation to engage in prostitution, again, because of YouTube, I have to be careful about how I say things, from in or about 2009 through in or about 2024. So again, those things, which is why this freak off stuff keeps coming up, were allegedly occurring pretty much through to the present. Okay, so now they break it down according to the types of things that the court needs to consider. So remember those factors that I told you about earlier, because now they actually are giving the court a glimpse of the types of things that are going to come up, that they anticipate coming up in trial. The evidence that they're going to proffer by way of witnesses and any other physical evidence they have, videos, audio, whatever. But they're going to do it within the context of the factors related to bond. So first, his use of violence, threats, and coercion. They say that since 2008, at least 2008, because of course the argument, and that came up as well, is that this stuff goes back much further, but 2008, as we discussed yesterday, magic number, because there's statute of limitations issues they have to deal with. Okay, so they talk about the fact that at least since then, his racketeering enterprise, so himself and the members and associates of his racketeering enterprise, we again discussed in part 1 what that is. So those of you who haven't had a chance, please go listen to part 1. I break down all of that in terms of what the enterprise means. Um, it also includes his multifaceted business empire, that he wielded his power and prestige, his reputation as a musician, an entrepreneur, a figure in the industry, to commit crimes, including racketeering, sex trafficking, and other offenses. And that those crimes, most of which involved sexual abuse and exploitation of women and other crimes of violence. We know from reading other documents, particularly the indictments, that there were allegations that he threw things at employees, hell, that he even threw people. So, so hello, you're dreaming right now. Welcome to the chat. Okay, so let's get back into it. Okay, so XX trafficking and abuse. Allegedly, he used that power to get them by force or threats and coercion to cause the female victims to engage in sexual activity, which included frequent acts with male commercial workers. We know what kind of workers that the defendant referred to as freak offs. We're going to hear that a lot. I'm just going to call them FOs because it just sounds goofy. Allegedly, these were elaborate performances that he arranged, directed, and pleasured himself during, and often electronically recorded. FOs occurred regularly from at least in or around 2009 through to this year, sometimes lasting multiple days, including multiple workers. And these were arranged with assistance from members and associates of the enterprise, including his employees. Hotel rooms were staged. There was significant damages, allegedly. They talked about the controlled substances. This, again, is going to be very important in the main case. Obviously, they're giving the court a glimpse of it for this bond hearing. It's going to be very important in the main case, particularly the types of substances, especially when we talk about substances like ketamine, ecstasy, and most importantly, gamma hydroxybutyrate, also known as GHB. GHB is also known as the date, R8 drug. So, and these things were allegedly often given to female victims so they could and would continue to engage despite fatigue, physical, emotional exhaustion, and pain. And quite frankly, if GHB was used, there certainly is a question about whether or not these individuals were truly mentally present, mentally and physically present. I mean, I guess physically present, but present from the standpoint of consent. Because as we know, just like in the R. Kelly case, there's going to be a lot of folks who are going to say, you know what, if they went and they knew what was up, then oh well. Well, when we start talking about the mix of heavy intoxicants, especially when one is known and routinely used for the express purpose of destabilizing people so that they can be taken advantage of, which is why it has the moniker of being the date grape drug, that's a problem. And if we're talking about mixing them, then this isn't just a party drug situation. Now we're talking about, going down the Bill Cosby road of situations. Okay. Additionally, during the FOs, allegedly the women would be subjected to physical, emotional, and verbal abuse, in part to cause them to engage. Allegedly, he hit, threw, kicked, and dragged the female victims, sometimes by their hair. At least a dozen witnesses will confirm that they personally observed his violence towards women and/or the injuries sustained by the women at his hand. again, remember, there are a lot of people who were already interviewed and who continue to be interviewed, given the number of subpoenas that were claimed to be sent out. A dozen people is more than enough to make a point, especially if they're all saying the same thing. That doesn't mean it's a slam dunk. As I talked about yesterday, there's a lot of elements to these charges that a solid lawyer can make some solid arguments about whether or not the government is meeting. So this is one of those that I think, as the discovery process goes on, and we may not know, obviously, but his attorneys will know when there is some understanding, especially by the defense, of exactly what the evidence is that the AUSA has, particularly anything related to photographic evidence, video evidence, audio. There's alleged recordings of telephone calls. Those things are going to be huge in all of this, because there are some concerns that I have, and I think even some other anyone who has done this type of law have, about whether or not there's a bit of a stretch with some of this. Not all of it. My concerns really are not so much with the Essex trafficking case, especially as they continue to unearth victims. I think that if folks are being moved across state lines, especially if money is exchanging hands, particularly if there are handoffs of some of these women and men to other individuals, if there is questions about consent because of the pervasive use of intoxicants, then I think that the Essex trafficking, and perhaps even the transporting case, while nothing is a slam dunk, I think that those cases might actually have some meat to them. It's the racketeering case that I think is the one where there's a much better chance of poking holes, especially when we're talking about a conspiracy racketeering situation, and conspiracy requires agreement, but you're basically saying that this person was this monster and megalomaniac that everybody was afraid of. So did everybody around that person agree to do these things, actually agree from the standard of being a part of a vast conspiracy? Or were these individuals just doing a job at the behest of a monster that they were afraid of? Now, of course, to make that argument, your client has to be okay with you saying, okay, fine, my client is a monster. Were they running a racketeering scheme? No. But yeah, they were a monster. They were a tyrant. Employees were afraid of them. So whatever he told them to do, they just did. Not because they agreed to anything, because they thought it was okay, and all of this other stuff that, again, gets you into the whole criminal enterprise route. We'll spend more time on that on a different day. Let's just focus on this bond hearing. Okay, so back to this. So again, we know that the FOs were out of control, according to, it just sounds wild. Allegedly, one incident they get into, obviously it's the incident with Miss Ventura, the one where that unfortunate video was released to the public. One incident of physical abuse occurred when a female victim was attending to leave the hotel following a March 2016 FO. It was captured on video surveillance and publicly reported in May of 2024. So we know which situation that was. That was the elevator. Another thing in the footnote, so this just gives an example of how off the chain this situation allegedly was. In 2012, after one of these so-called FOs, the defendant, Mr. Combs, had to paid over $46,000 to cover the damages to a penthouse hotel room following an FO. How many people were there? What were they doing? And were they, I mean, you got to wonder if they truly were hanging from the chandeliers. We're talking about almost $50,000 worth of damage. That is essentially remodeling that entire suite. I mean, seriously. If you've ever done any remodeling to a home, $50,000 puts in a pool, a quite a nice pool, by the way. $50,000 is a state-of-the-art kitchen or a couple of bathrooms. Or if it's just a regular home, like most of us regular people live in, 50 grand is literally a full remodel, including furniture, getting your walls done, some new curtains. That is serious. So we're talking about a full remodel of a hotel room after this person stayed there. I got to see the receipts. And I mean, literally, the receipts to see what they had to fix. They talk about how they were coerced, essentially casting couch type situations, and beyond that, right? Coercion by controlling your careers, finances, livelihood, housing, among other aspects of their lives. Of course, if this involved his artist, then obviously we know record deals or anything like that. So we get it. The powerful people can control things. Other violence. In addition to the physical, sexual, and emotional abuse of romantic partners, he allegedly repeatedly engaged in acts of violence directed towards his employees and others. We've heard these stories for years. This is nothing new. It's just a matter of whether or not the individuals are actually going to admit it, and if the court finds those individuals to be credible. As charged in the indictment, the defendant, often assisted by, again, members and associates of the enterprise, engaged in arson, again, physical violence such as throwing objects at people, throwing people to the ground, hitting, dragging, choking, shoving them, even kidnapping. There were other witnesses who allegedly witnessed firsthand drama and sustained trauma as a result. In the morning hours of one incident they talk about is in the morning hours of December 22nd, 2011, the defendant and a co-conspirator basically snatched up someone at weapon point to facilitate breaking into and entering the residence of someone else. Multiple witnesses would testify at trial to the defense, to the events surrounding that abduction and the break-in, and it was corroborated, at least the break-in part, was corroborated by police reports and other records. Approximately 2 weeks later, those individuals allegedly set fire to that person's vehicle by slicing open the car's convertible top and dropping a Molotov cocktail inside. So again, we're going to guess that this was probably Kid Cudi based on the timing, especially when you connect it to Cassie Ventura's lawsuit and some of the things she recounted there. More broadly, since 2008, again, more abuse of women that has been reported in the media, including on blogs and podcasts. Law enforcement reports corroborate that police responded to several incidents of violence, including the assaults. More recently, there's been an outpouring of other public allegations against him as well, including claims of threats and physical and sexual violence dating as far back to the 90s. In short, the defendant's violent tendencies are widely known. Again, nothing new. Next, the arms. Okay, again, because of YouTube, I've got to be careful about how I say this, but the bottom line is Mr. Combs and his security personnel at times often carried arms. We have a right to bear arms in this country, of course, and he was a public figure. He was also in the hip hop community. And of course, he's had associations not only with individuals who have lost their lives, but individuals who are living, but also nefarious and characters for a multitude of reasons. So that wouldn't be outside of the ordinary for him to have weapons. I think the concern with weapons is with him is if you are a violent person, if you are brandishing them, if you are using them, which they talk about here. So I'm basically saying, just paraphrasing what they're saying, if you're brandishing them, using them to intimidate or threaten others, that is where it comes into play. Yes, you have a right to bear arms. You do not have a right to do those things. And it is literally against the law to do those things. Brandishing and using it to threaten or intimidate others. There's literally legal statutes against those things. Okay. Again, and you make your victims aware. At least on one occasion, he allegedly forced a female victim to carry one on his behalf. Again, we saw that in the Ventura lawsuit. He allegedly pointed them at individuals. There are also there were some illegal arms that come into play here because when his home was raided in 2024, there were searches, of course, in his Miami and Los Angeles homes. They found AR-15s, each with the face serial numbers. You cannot do that, as well as large capacity drum magazines. Both of those things were loaded. There's even a picture in here so that you can see that that those serial numbers were filed off. And of course, you can't do that if you're going to have weapons, even assault weapons, and whether we like it or not, those are no longer illegal, at least for the moment. Then you certainly can't have serial numbers filed off. So again, that's the deal on that. There were other weapons that were legally purchased. There were 6 of them. By the way, one of the large capacity drum machines had 59 rounds in it. Another one had 30. In addition, there were others, both. So he had legal and illegal weapons and ammo. And even if he were personally, and they talk about the fact that even if he were personally restricted from having weapons, he could gain access to them through others. So again, they sum this up by saying, in sum, his regular use of violence and threats to others with violence and coercion, again, problematic. This is one of the most hard-hitting parts that we're coming up to right here that speak to is if they threw out everything else and never argued one other word. You have the fact that there are allegations of witness intimidation and bribery. That, no matter what you're charged with, is going to be a huge problem. And even if you had bond and they found that out about you, they'd lock your ass up. So, allegedly, he bribed witnesses and obstructed justice throughout the time period charged in the indictment, when he faced the possibility that his violent and criminal conduct would become public, the defendant and other members and associates of the enterprise pressured witnesses and victims not to report what they saw or heard to law enforcement or to otherwise conceal criminal conduct. And we also remember in the Cassie Ventura lawsuit, she talked about when you leaving, and it wouldn't just be him involved in the coercion to come back. There would be managers or attorneys and whomever else. Okay, so this is one. They have a couple of instances. For example, as noted above, in March 2016, he was captured on video. So that's the striking of, that's the individual, the situation with Cassie. So we know that. But the other piece is when a member of the hotel security staff intervened, he attempted to offer the security officer a stack of cash to ensure his silence. After the security guard refused his bribe, and after coordination between the defendant and employees, the defendant's staff contacted other members of hotel security. At the same time, staff members were in close communication with the victim of the assault, all in an effort to cover everything up. Within days of the incident, the surveillance video disappeared from the hotel's server. But as we know, somebody kept a copy. Similarly, throughout the time period charged in the indictment, members and associates have reached out to multiple victims on behalf of the defendant to convince them not to report the defendant's abuse. Most recently, in late 2023, immediately following public allegations of certain of defendant's crimes, including his physical and sexual abuse of women, the defendant and other members of the enterprise made repeated phone calls to victims and witnesses, during which they provided victims and witnesses with false narratives of events in an effort to conceal the defendant's crimes. On at least 2 occasions, the defendant recorded those calls on a co-conspirator's cell phone, thereby attempting to obscure his involvement in the obstruction. Why would you record it? Why would you record it? But we know why you record it, because people do things like that thinking they're smart, thinking that they are setting up mutually assured destruction. You tell on me, I tell on you, I have the tape. But if the tape comes out, you've still told on you. Okay, fine. Let's see. Are there any questions in the chat? Okay. All right. So back to this. So we also know, as they talk about, that the investigation is ongoing, and that's important. They want the court to know that, because with his indictment being unsealed, the investigation into his and other co-conspirators' conduct is active and ongoing. The people keep asking, where are these co-conspirators? Why haven't they been charged? Well, there's a number of reasons. Either A, they're cooperating, or B, their indictments are under seal and they're coming. There are situations where sometimes co-conspirators, there are literally years between the time that one person's indictment is unsealed versus another. I talked in part 1 of this about the Jen Shah case, Jen Shah from the Real Housewives of Salt Lake City, who went down about, I guess, going on about a year ago now, for telecommunications fraud and some other stuff. But they were all kind of related to that. There were individuals in her case who were indicted a full 2 years before the indictments against her and her assistant, Jen Shah and her assistant, were unsealed. And those individuals' cases were active, ongoing. In fact, by the time her indictment was unsealed, almost everybody had taken pleas. They had already made deals and were getting ready to serve whatever time that they had negotiated in their respective cases. So it is not telling of anything one way or the other when it comes to the other right now co-conspirators who have been who have not been charged or who have not been indicted. They may not be. Those indictments may simply stay under seal and they may never be indicted. Or those indictments may be held with a possible negotiation of pleas and testimony. There is a lot of moving parts in cases like this, especially when you are alleging a potential conspiracy, especially when it is so clear that there is one or more individuals that are really the nucleus of everything, and everybody else is, are sort of peon level or mid-level peon. So let's see. So the investigation is ongoing. They're not going to tell everything. We know that. And of course, there is a concern about the individuals. They get into the applicable law. The applicable law is basically what I told you. We have a Bail Reform Act that the federal courts are empowered to order detention. But of course, there are things that they consider. Of course, we know that one of the things, because I talked to you all about it already, risk of flight, obstruction of justice. Obstruction of justice is really important, and they talk about the evidentiary standard involved and the other factors that must be involved: the nature and circumstances, the weight of evidence against the person, the history of circumstances, the history and characteristics, so character, past conduct, and the nature and seriousness of danger to any person or the community that would be posed by the person's release. Again, huge here. Prior acts of domestic violence are relevant. So again, even if the person isn't convicted, we are also talking about character, and we're also talking about things that they may or may not have admitted to, or in Diddy's case, there's video and a whole bunch of people going, we saw it, we saw that, and we saw a whole bunch of other stuff like that. Evidentiary rules do not apply at detention hearings, and the government is entitled to present any evidence by way of proffer or other means, which means they don't have to bring in a litany of witnesses. They can simply stand there and argue it. And in fairness, the defense does the same thing. When I do bond hearings, it's literally them, the prosecution standing on their side, I'm standing on my side. And there are a lot of times where the defendant or others don't say a word. We may inquire of the pretrial person who's there, who may have interviewed our client. I may, if there's some questions that pretrial just still couldn't solidify, I may have to ask my client about, in simple stuff, because we don't want to possibly step into anything regarding the case. But sometimes there's simple things like, they couldn't reach your mom at the number that you gave them. Please tell the court right here on the record, under oath, that you do live at 1234 Mockingbird Lane, and that 1, 2, 3, 4, 5, 6, 7, 8 is your phone number. Those types of things. You do work at Jiffy Lube. They talk about his dangerousness, and they really, because like I said, there's certain things that they were going to focus on. They don't care about the money and all of that stuff. Going to zero in on the danger. So they talk about the dangerousness of it. They get a little bit deeper into the crimes. They start talking about his disposition towards violence and his abuse, and the fact that it often happens behind closed doors and hotels and all of these things, that he organizes these parties. They talk about the fact that he is a serial abuser who repeatedly assaults and coerces individuals, and that there are no restrictions that are going to curb his violent conduct if he is in the community, with everyone else. He has a long-standing, this is according to them, so allegedly he has a long-standing pattern of abuse, and it's probative evidence of the likelihood that he will continue to do it. He has continued, allegedly, to continue to physically assault and threaten those around him, including his romantic partners, employees, and others. So they want the court to know there's nothing that you can do to fix this. Obstruction, the same thing. And they talk about the behavior, about the fact that after that, after the November case, that after that November case was filed, that again, he continued to contact people. Let's see. After the physical lawsuit, after the lawsuit, the Ventura lawsuit was filed, they talk about his own statement in no uncertain terms. Let me be absolutely clear. I did not do any of the awful things being alleged through counsel. He vehemently denies these offenses and outrageous allegations, describing the complaint as riddled with baseless and outrageous lies. And we remember that at the time of the Ventura suit. It wasn't until the video came out, then he talked about the fact that he had in fact done the act and that, he needed help. His attorney yesterday did not help when he started to shift a little into victim blaming and started to talk about the fact that essentially Cassie, she started it. Let's see. For example, on November 19th, just 3 days after the filing of the lawsuit, the defendant made multiple phone calls to another victim of his abuse and recorded certain of those calls using the cell phone of a co-conspirator. Now, this was just done. During the calls, he repeatedly asked for her support and friendship and attempted to convince the victim that she had willfully engaged in the acts constituting as sexual abuse. He assured her that if she needed the defendant to, she, quote, ain't got worry about nothing else, unquote, a thinly veiled attempt to coerce her into adopting and supporting his false version of events to protect him. Even more concerning, since learning about the criminal investigation, including following the execution of the search warrant, he contacted other witnesses on multiple occasions, including witnesses who received grand jury subpoenas. They give some cases that were similar to this, and they talked about why the court found, there's one case in particular that they talk about the court finding it sufficient to revoke bond. Now, that person was already on bond because they had taken multiple proactive steps to tamper with potential witnesses against them. So that's the case is called LaFontaine. So the government is aware through electronic evidence, toll records, conversations with witnesses, and other evidence that he has contacted witnesses, including subpoenaed ones, and other evidence that he has contacted witnesses. Including subpoenaed ones prior to the dates on which they were required to appear before the grand jury. He recorded calls with at least one and provided intermediaries. So not good. Risk of flight. They say he's a risk of flight. They talk about, it's obvious. They talk about the fact that he's charged with offenses that could carry up to life. Anybody would want to escape. And of course, given his vast resources and his proclivities and what appears to be a need to do the things that he does, that risk of flight is a concern. They say that risk of flight is augmented by the nature of the evidence against him. The evidence against the defendant, which would be made public at trial, includes substantial evidence that is highly sensitive and has the potential to significantly and negatively impact his reputation. For example, dozens of video recordings created by the defendants of the freak off with victims. For decades, he has spent significant time and resources ensuring that his criminal conduct avoids public scrutiny. So essentially, they're saying that there's a lot of ish, and we know the kind of stuff it probably is, that there are a lot of things that would be so concerning and embarrassing to him that it would make him want to run, that he knows that there's no recovering from them, especially when we're talking about videos, because if you're just spanking it while you are watching other people do things, who cares? But if you are involved in doing things or things being done to you, well, we know how toxic masculinity works. We also know that in the hip hop community, there are just certain things that are not going to be tolerated, and we're going to leave it at that. The defendant's incentive to flee outlined above, coupled with his seemingly limitless resources, creates significant risk of non-appearance. His net worth is publicly estimated at being close to $1 billion. And remember, he wanted everybody to know that. Indeed, the investigation of this case has revealed that he has access to vast funds and resources, including, this part is interesting, deep reserves of cash, which facilitate his evasion of prosecution. So he likes to keep cash around in addition to his investments. At least as of December 2023, the defendant had access to dozens of bank accounts, some personal and many under corporate entities. And those are just the corporate entities that we know about, not the shell corps, not overseas corps, not corporations that are along with other people, not the vast business partners, which contain millions of dollars. Additionally, as of December 2023, the defendant had over $1 million in personal cash on hand. He has traveled internationally several times per year since at least 2006, and since approximately 2019 has owned a personal plane on which he has traveled internationally. And of course, then it talks about his residences. The cash thing. Cash is king, cash is key, and having a lot of cash on hand is very interesting, especially when we talk about fleeing. The weight of evidence and considering the danger and risk of flight presented by the defendant, the court is also required to consider the weight of evidence. So we talked about that. So I'll just skip down to some of the standout features. As to witnesses, to date, the government has conducted interviews with over 50 victims and witnesses, many of whom saw or experienced the defendant's abuse. Many of these witnesses corroborate one another, and their accounts are similarly consistent with the other types of evidence discussed below. The government only expects that number to continue to grow, given that the investigation, which is now public, is ongoing. The electronic evidence is similarly vast. Now hold tight to your seats, folks, on this. The government has sought and obtained numerous search warrants for such evidence, in addition to obtaining evidence voluntarily from certain victims and witnesses. Setting aside devices seized in connection with the defendant's arrest, the government has obtained over 90 cell phones, laptops, and cloud storage accounts, as well as over 30 other electronic and storage devices, such as hard drives, thumb drives, cameras, and surveillance system. This electronic data comes from the defendant himself, as well as co-conspirators, victims, and witnesses, and chronicles much of the defendant's criminal activity as it occurs. Now, again, some of these cell phones, laptops, cloud storage accounts, documents belong to other people, but that is still significant in terms of the amount, just the sheer amount of data that is being combed through, no pun intended, in this case. There's also allegedly physical evidence, which was seized pursuant to search warrants executed, as well as on his person, in addition to the arms and electronics discussed above. The evidence also includes other evidence of FOs, including over 1,000 bottles of baby oil and personal lubricant. I'm still going to hold out that there was going to just be a really, really slippery pool party. The evidence includes business records obtained pursuant to over 300 grand jury subpoenas and other voluntary productions. These materials come from over 100 entities and individuals, including communications providers, tech companies, social media companies, banks, and other financial institutions, airlines, hotels, car services, and other travel-related companies, escort services, and even the defendants' companies and wealth management firms. So they are far from done. Of course, this last paragraph, we know they kind of finish how they start, that the proposed bail package is insufficient. And it's not because of the amount or any of that. I mean, 50 million, secured property, all of that. It is really because at the end of the day, they are arguing that there is no amount of money that, or there's no conditions. It's not even really money, that there are no conditions short of literally just an 8x8 with bars that is going to keep someone with his proclivities, resources, and all the things from either running or continuing to do what they allege they have evidence of him doing, which is contacting and attempting to go after witnesses. Okay, so that was a lot. Now let's get into his attorney's appeal there. So he did his appeal letter today. So yesterday, they argued in open court after he submitted the bond package, which I went over earlier, and which has been floating around online. That's the whole 50 million. We're going to be locked in house. We're going to give up plane, trains, automobiles, all of that. And let's just get into today. Yesterday, it was argument as it relates to that. Judge said, hell no. Okay, so today we are getting into the full-blown thing. And I mean, they submitted their own 15 pages and over in a package with over 100 pages of exhibits. A lot of it was communications back and forth between the attorneys in Combs and the attorneys in the AUSA, just attempting to show the court evidence of this alleged cooperation that the AUSA is like, what do you mean cooperation? There is no freaking cooperation. They did the bare minimum of what you're supposed to do, which is try to prepare and negotiate their client turning himself in. They turned over evidence in addition to the evidence we seized because it was going to be worse for them if they did. You know, that type of thing. It's kind of that whole I quit. No, you didn't quit. You were fired kind of thing. So they submitted the letter in lieu of a formal motion because, again, you know, it was today and they're trying to get their client out of Rikers. By the way, this is in front of Judge Andrew L. Carter. He is a different judge from the one that heard the matter yesterday. And some think that there's even the possibility that this could be the judge that ultimately hears the case. This early in the game, I think that that's an ambitious call to make because there's such a long way to go in this matter. Unless there were literally a plea deal next week, we really can't call it on who's going to deal with this case. Now, granted, this judge is learning a lot about this case earlier because of these lengthy motions and these lengthy memos. But again, this is a federal court. Everything is lengthy, especially because it's federal court. And a lot of the cases end up being serious. And then you got some serious attorneying going on. Okay, so Mr. Combs, through his counsel, submits this letter in lieu of a formal motion, and it'll walk the court through the actions taken by Mr. Combs over the past 6 months that they view as unprecedented, and will prove that he is not a risk of flight or danger to the community because he has shown himself to be trustworthy and committed to going through the process of showing his innocence. So essentially, basically saying my client should get bond because they have been following the steps needed to get to this point, and they will continue to do that because they want to clear their name. They want to have their day in court. They don't want to run away and have this hanging over their head like some lifelong Roman Polanski drama. They don't want the stink of suspicion of a Russell Simmons. They want to, my client, Mr. Combs, wants to deal with these matters. So he is following the steps, Your Honor. He is doing the things of the things of the things. So Mr. Combs flew to New York on September 5th to surrender. So they want the court to know that when it became apparent that he was going to be charged, he did something extraordinary. He left his home in Miami and traveled to New York to surrender. Now, sir, I'm going to let you have it because, again, I pride myself on my ability to, as a judge told me once, turn a sow's ear into a silk purse. So, it's what we do, right? We are defense attorneys, and we spend a lot of time trying to put lipstick on pigs to make them look more like, well, not pigs with lipstick. So we told prosecutors he was in New York to surrender. We asked them for a time to surrender. They never got back to us. They withheld this information solely so they could arrest him and not allow him to surrender, which he flew to New York to do. Instead, the government effected an arrest 2 nights ago solely so it could argue for detention. Even if he turned himself in, again, we've already talked about it. These charges carry the presumption of detention, so he was probably going to be detained anyway. All of this legal wrangling that we're doing in court was going to happen when it comes to detention because his charges carry a presumption against it. AUSA Williams was not going to say, well, since we made arrangements for him to turn himself in, as opposed to us coming and picking him up and giving him a ride at our expense to the station, he can go home. No, that was never going to be the plan. You were always going to have to write this 15-page letter. You were always going to have to submit that bond package. That is why you had it ready, whether he turned himself in or what have you. But I feel you. Let's keep putting that lipstick on. However, surrendering himself to the prosecutors was not the first action he took to show his trustworthiness. It's been a pattern since even before March 25th. He has been fully, they say that Mr. Combs and his counsel have been fully aware that the United States Attorney for the Southern District of New York has been conducting an investigation involving allegations concerning racketeering and sex trafficking. So were all the rest of us. Everybody knew this was coming in one form or another. Knowing that for many months he would be indicted, he's done everything, which they'll set out below, in order to, in ways that his attorney is claiming is unprecedented. Again, I'm not hating on the flowery language. We have to do what we can for our clients. So if we're saying that, so if unprecedented is the word of the day, then damn it, Mr. Agnifilo, we're going to go with that. Unprecedented. We respectfully submit that Mr. Combs can rebut the presumption of detention here due to his extraordinary actions in this investigation. So there's the proposed package. We talked about that earlier. The money, the passports, the planes, trains, automobiles, the houses, all of that. They get into the history of this investigation. So they talk about on March 13, 2024, that Mr. Combs emailed the assistant U.S. attorneys and he identified himself, or counsel identified himself as counsel for Mr. Combs, said that he wished to speak with the prosecutors and share information about these matters. After not hearing back from the AUSA's counsel emailed the prosecutors again. And a lot of this stuff that they're talking about, these are the exhibits that were submitted. So basically, he's saying, we were trying to get in touch with you so that we could try to work something out, find out what you need, and maybe soft shoe this a bit, as opposed to where this ultimately went, which is that big March 25th raid. I also think that this is one of those areas where it gets a little messy, right? Because on the one hand, you're saying, look, we were trying to contact you damn near the whole month of March before that raid happened to say, look, meet with us. We'll talk to you. We'll cooperate with you. What do you need from us? Let's figure this out. We know you're investigating my client, all of that. But then you did the raid your way. Okay. But there's an important piece missing here. The day that all went down, your client, who you are claiming was ready to cooperate in every way, so much so that you were sending friendly emails a mere 2 weeks before, was at the private airport, along with an associate with a bag of drugs. So, okay. I'm just throwing it out there. But again, I'm with you. We're putting lipstick on that pig. Counsel took possession of Mr. Combs' passport on April 1st. Good move. Good move. To just show I'm not leaving. He ain't going nowhere. I know that was cheesy. That was cheesy. Okay. So counsel agreed to advise the government of all domestic travel. So counsel said that whenever Mr. Combs traveled, starting from pretty much the time that he took his passport and throughout the rest of the investigation, that he told the AUSA everywhere he was going. And again, he submitted exhibits where he kept those promises by sending emails or other manner of communication to say, hey, and my client's traveling from Miami to Los Angeles to go on a trip with his kids. This was back in June. And then later in June that he was flying to Wyoming on a craft. So again, those exhibits have been submitted. Nobody's saying he's lying. He also says that in May, he also advised the AUSA of Mr. Combs' efforts to sell his plane. So that started, and at least over several months, there's been some potential buyers, in fact, two that signed letters of intent to purchase the aircraft. And, you know, life happens. And I guess in the life of people who are able to buy planes, other things came up, and for whatever reason, they just didn't buy them. That he voluntarily, they talk about him voluntarily relocating to New York. The assistance concerning subpoenas, that there was, that he agreed to accept service on behalf of Mr. Combs, that there were other counsel for the other entities, the other businesses that they, of course, have had, that they have accepted subpoenas. There's been regular discussions about documents that have been turned over. And so all of those things have been done. He even said that ultimately Mr. Combs has produced over 144,000 pages of documents to the Southern District of New York in compliance with various subpoenas that have been issued. And that he did that because he didn't have anything to hide. Paying off the mortgage, we talked about that he paid off the mortgage in anticipation of making sure that he would have as much unencumbered property as possible in anticipation of posting a substantial bond, whether it was one he offered or one that was ordered. The legal standard, they talk about that he's innocent until proven guilty, and that liberty is the norm. Detention prior to trial without bail is with it should happen, that it shouldn't happen except in exceptional circumstances, or as they say, with limited exceptions. As I talked about earlier, there are certain categories of crimes that carry that presumption no matter what. So yes, while we understand that we don't want people to just languish in jail, at the same time, if there are if they fall into those categories of crimes, and of course, as we know, those other standards, risk of flight, danger to the community, then that is going to overcome that presumption of liberty while your case is pending as well. And they even talk about that. When deciding an issue of pretrial release, the Second Circuit has noted that the court should bear in mind that it is only a limited number of offenders who should be denied bail pending trial. So take that and do with it. There is a presumption of detention in sex trafficking cases. This presumption is rebuttable. We know that. And it imposes on the defendant that burden of rebutting the presumption. Now, later on at trial, the burden of proof is on the prosecution. But for this, the burden is on the defendant. And so they have to produce evidence that is contrary to the things that that the court is going to consider. I think that they tried. I just don't think that they met that. They talk about his history and characteristics, but when you start talking about his history and character, it's hard to, yes, you are his attorney. So you're going to talk about all the good things, and you're going to characterize those things that are not so good in the best way you can. In this instance, they talk about him having a drug problem. They also talk about his philanthropy. And yes, there has been many philanthropic acts. We also know that a lot of unsavory people hide behind philanthropy, especially when it gets you huge tax write-offs. Not saying that that is Diddy. I am not saying that he doesn't love the Boys and Girls Club. He had an absolute wonderful reason for giving millions of dollars to the Boys and Girls Club, because he talks about the fact that the Boys and Girls Club meant a lot to him coming up. I don't doubt that two things can be true. He had millions to give, and this organization poured into him. And Boys and Girls Clubs of America, wonderful organization. So we get that. He also has supported the National Foundation for Teaching and Entrepreneurship. Huge endowments for scholarships at Howard University, $2 million there, $1 million to Jackson State in 2023. He donated to a charter school. We remember he did the whole charter school thing. He's raised millions of dollars for New York public schools, over $4 million for PPE during COVID for healthcare workers. He's been involved in the Vote or Die campaign. So lots of really great things that he has done. Again, more than one thing can be true about a person. And so I don't think that I don't think that we can just say that, oh, well, he did those things just so that he could cover up whatever. No, if he put in the work, he put in the work. And if he, like I said, if he put in the work, he put in the work, and he's got the Triumph Award, and he's got all kinds of awards. He's got Grammys and I'm not sure if he has an NAACP award. It's not mentioned here, but he certainly's got superhero award for Room to Read, Child of America award from the Carver Foundation. He's got an Icon award from the Apollo. They talked about him creating thousands of jobs, including valuable internships. We're not even going to get into the whole intern thing. That one can turn on you. Supported minority and women-owned businesses, leveraging them as key suppliers and vendors for his enterprises. As a businessman, I'm not going to say that there are not things. I don't think anybody can say that there aren't some really extraordinary things that he did on that part, on that front. And I will leave it up to, as we all should, the individuals who worked with him or for him to speak to that. We know that there's individuals who talk about the fact that they were not paid, the whole issue of ownership of their rights as it relates to their intellectual property, the writers, and all of that. Has there been scuttlebutt about that for years? Yes, but we're going to leave that to those individuals. They talk about the danger to the community issue, and just they did not really dig too deep in that into that. They simply tried to say that while the government claims that he was obstructing justice and and that he was doing all of these things as it relates to witnesses or thwarting the case, they claim that that is not the case at all, that he has done nothing to obstruct the investigation, and that in fact over the past 6 months he has rigorously cooperated by providing everything that they have done, that anybody who has been spoken to, that they have gone out of their way to avoid interviewing anybody who was grand jury witnesses, etc. And I'm sure Mr. I keep wanting to say Agnifilio because I just think it sounds really cool, but it's actually Agnifilo. I'm sure that you have. I'm going to give you that respect as a fellow officer of the court. The question is whether your client has, and the answer seems to be no, but okay. They go back to March 5th and they talk about the fact that he attempted to, they talk about him reaching, the March 5th incident. They talk about, I'm thinking of this past March. I apologize. So March 5th, 2016, they again talk about that incident, and they said that he publicly responded saying he didn't do any of the awful things that they did. His attorney tries to turn that and say, to be clear, preventing the truth of an embarrassing event in which Mr. Combs is caught on videotape in an alleged assault is not obstruction of justice. Okay, I'll give you that. We can, if we're going to do the whole, I mean, I guess it's a matter of semantics. You say potato, I say tomato type thing. It is not, it's not obstruction of justice. It's just lying. And yes, people do that when things are embarrassing. We get it. All right. Contacting potential victims and witnesses. They essentially just said they just deny it. They talk about and they specifically bring up the fact that the individual, because the prosecution brings it up and they brought it up in the hearing yesterday, on Tuesday rather, they talk about the fact that the prosecution brought up Mr. Combs's extensive contact of the young lady from Diddy Dirty Money. I believe her name is Kalima. And ultimately, after over 100 attempts at contacting her. I believe they were messages that she finally put up a statement, and that the prosecution was drawing a connection between the fact that she put up that statement, and that she put up that statement, and the fact that he contacted her so many times. And they say, as someone with an exact point of view of the civil plaintiff comes forward and says, in essence, and this is, I thought it was a soft, respectful statement. And the statement was, then this is what Kalima said. I'm not taking away from her experience. That wasn't mine. That wasn't my experience. She is entitled to her experience. I was there. That's not what I saw. That's not what I saw. That's two witnesses having divergent recollections of similar events. And I expect this trial is going to feature exactly that. So there's nothing wrong with that. That's why we have criminal trials and civil trials. So long short, his counsel is trying to distance Sean Combs away from the idea that him contacting these witnesses, first of all, is obstruction, is witness tampering, is all these other things, but that the situation with Dawn and Kalima wasn't a direct example of what can happen when a defendant does that, which is essentially that a potential witness feels compelled to say things in your favor after they have been potentially intimidated by you. They say the proposed package will address the government's stated concerns for witnesses. To be clear, they basically say that that, long story short, they say that the proposed package will address the concerns with him having any abusive relationships with anybody, or punishing anybody, or continuing any type of assaultive behavior, is particularly as it relates to the women or any of the FOs, also known as freak-offs, that they can be assured that those things will not happen, and that the package will assure that that will not happen, because he will not have any female non-family visitors to his house, and his security company will keep a record of all incoming and outgoing visitors. Now, that is technically, and we talked about that, and I'm scrolling up, that is technically not what it said. It said restrict female visitors to his home except for family or the mothers of his children. Now, we may have to just say the mothers of his children are non-family members. But the bottom line is, just keep everybody away. Just keep everybody away, and it'll be simple. Okay. So we talked about the factors. They went through all of that to the that they can also finally, that they can address the concerns that the court has with the obstruction of danger. So that's really simple. They talk about the fact that there is only one alleged ex-trafficking victim in the indictment, and the government can say what it wants, but they only charge as it relates to one victim. Charge 2 only mentions victim 1 as well. There's no victim 2. So essentially they're saying they're basically saying that that's Cassie, and that she has had her own situation. They also go through the fact that she hired a lawyer, that she tried to extort him, and all of those, all of those things. So basically, long short, that there is no possible going after anybody else and that no one else would be in danger, because the only person at issue here is Cassie, and that he is no danger to her at all, because she has her own life and she's doing her own thing. It'll be very interesting to see how this bears itself out with the alleged victims, because while I do agree that they specifically cite victim one said this, victim one said that. That doesn't mean that there aren't other victims. It simply means that there's only one that they use to give some specifications, or to give some specifics in the indictment. Because again, the indictment doesn't have to tell everything. It just needs to be informative of what your charges are. The grand jury is who heard everything, or at least enough. Not everything, but enough. At yesterday's bail hearing, they talk about the SX trafficking cases in the southern and eastern districts, and they mention the fact that the court, or rather not the court, but that the prosecution brought up R. Kelly, that they brought up Epstein, they brought up Keith Raniere, they also brought up Ghislaine Maxwell, and essentially they're trying to distinguish him from those cases and say that in many of those cases, those individuals try to, for instance, in the case of Maxwell, that they try to evade detention, and just again distinguishing his level of cooperation from their level of cooperation. Also, the level of restrictions they would be able to provide. Of course, as we know, in the case of R. Kelly, at one point he was out and then his bond was revoked. So they, again, they just want to make sure that their client is distinguished from those individuals who they say didn't truly cooperate, or just flat out removed themselves and tried to evade prosecution altogether. And so that is basically what they say. We know that the prosecution submitted a second document. I'm not going to go fully into that. I'm just going to bring up the items that they talk about in terms of him being a significant and ongoing danger. And about the counts, because they did want to address that. So I'm going to talk about the number of the victims. Okay, so they say, to be clear, despite the indictment naming one victim, and remember, I just mentioned that, despite the indictment naming one victim in count 2, this case is not about just one victim. The government's evidence to date, including the defendant's own communications, demonstrates that the defendant has used force and coercion against multiple victims. In addition to these women, the defendant has assaulted a host of other individuals, including his employees and witnesses to his violence. For example, the defendant directed his rage towards his employees and those close to victim 1, who had seen him physically abuse victim 1, including by throwing these witnesses against walls and onto the ground, choking them and throwing objects at them, among other things, particularly when they attempted to protect victim 1. In doing so, he has demonstrated that he is not only a danger to the victims and witnesses, but is also obstructive and willing to engage whatever is necessary, including physical violence, to instill fear in witnesses to keep them silent. Equally, as outlined in the government's September 17th letter, he poses a significant risk of obstruction. And then they talked about what happened as it relates to that. Defense counsel acknowledges that the defendant has contacted witnesses in this investigation, apparently with counsel's blessing, but claims the defense has studiously avoided interviewing grand jury witnesses. That's key, because sometimes your own words could slap you in the face. I'm trying to find the part where it says, okay. So finally, it bears noting that within the first 24 hours of this case's unsealing, there are already new concerns about witness interference, as well as interference with a fair trial based on the defendant and his counsel's attempts to publicly discredit one of the victims. As Judge Tarnowski noted in her ruling, one of the pertinent concerns here is the power imbalance in the case. The defendant, as alleged in the indictment, is and publicly known, is a man of immense power and influence. Consequently, his ability to coerce victims and to influence witnesses is outsized. And I also wanted to bring up, I can't find it in here. I think it was just something that they talked about in court. Again, they mentioned that he attempted to contact Kalima via text 124 times the day that Dawn's case was filed. The defendant's attempt to distinguish recent SX trafficking cases. So they're talking about his detention being consistent with the law. And they talked about the ruling in rulings in other cases where obstruction was a concern. For instance, in Epstein, Judge Berman ordered the defendant detained on dangerousness, obstruction, and flight and risk of flight grounds, despite the fact that he charged conduct as well as the bulk of obstructive conduct took place approximately 1 decade prior. So essentially, even though most of that conduct involving Epstein, it was more than 10 years before in terms of the things he did to try to avoid and deal with witnesses and all of that, the judge still felt that he was a danger. That there were numerous attempts to intimidate, harass, buy off potential witnesses, all of that. Similarly, in the R. Kelly case, U.S. versus Kelly, the defendant was detained on dangerousness, obstruction, and risk of flight grounds. There, the court found that the defendant's dangerousness, based on the seriousness of the charges, which dated back more than a decade and included sexual and physical abuse of minors and adults alike, such as hitting, slapping, punching, and spanking. The court also found that the defendant's obstructive conduct and witness tampering, which related to the matters charged, were grounds for detention. The judge denied the defendant bail in United States versus Rainier, noting that the defendant posed a danger to the community due to the nature and circumstances of the charged sex trafficking conduct, which did not, at the time of the bail determination, include allegations involving minors, and crediting the government's representations that NXIVM critics and defectors face harassment. So remember, Rainier is the NXIVM guy. I forgot to mention that earlier. So these individuals are routinely detained during pretrial. So it's not just a presumption, it routinely happens. And that's what they were arguing. Okay, so now we've gone through it and we know that ultimately the court has said no. Let's see, the AP, based on current CNN interview regarding, do you believe that he has the appropriate representation? Interesting question. I honestly didn't find that his attorney did anything that most attorneys under that many, I wouldn't say most, that many attorneys under the circumstances wouldn't do. I think that he came off as well prepared and ready to go. He clearly has a team that was ready to write motions. They apparently have been cooperating up until this point. So I don't necessarily think that he has bad representation. I think that sometimes when you have a client with a messy case, initially there might be some windmilling. And I think that that is what his attorney did. His attorney went in there just trying anything to get his client out. I think the bond package was very well put together. It was smart. It addressed everything that the court would need to address. I just think that he has a client who right now is being looked at is like he's Darth Vader. And that's just a tough one. I'm going to go back and I'm going to watch court. I'm going to watch a CNN interview. I did, obviously I got the information regarding court, and I've read the pleadings. I've read the there's been a couple of people who have done a fabulous play-by-play of what's going on in court that was practically a transcript on Twitter. So I was able to read what the arguments were. I think the only place where he lost me is I think that he went a little bit too deep down the rabbit hole as it relates to Cassie Ventura in terms of trying to cast her in the unsympathetic victim role and trying to recharacterize that situation. I think when it comes to the Cassie Ventura situation, that's one of the ones that you just got to let him have it. You just really do. I'm not saying that you don't try to fight for your client, but what you can't do in a situation, especially once that video was released, when you've got two things working against you. You got a client who, whether it was because he wanted to or whether it was because all of the insurance companies were like, no, this is what we're doing. The bottom line is, no matter how it happened, the case was settled in less than 24 hours. So you've got that piece. Then you have the added piece of the video, which lent credibility to what was said in the suit, and of course, underscored the fact that it was settled within 24 hours. I don't think that is a bell that you can unring, and you damn sure can't unring it by getting into well, she saw something in his phone, they were cheating on each other, she got up in his face, blah blah, trying to do the whole Chris Brown Rihanna thing. That's not going to work here. That's not. I think when it comes to the Cassie thing, you just have to eat it. So that is the one area where he lost me. Other than that, and again, I have not seen the CNN interview, but it just based purely on court performance and what he attempted to do for his client on the bond level, and the manner of at least attempting to characterize him as someone who is cooperative and, just doing everything the right way. I think you got to work with the client you got. And at least at this point, especially since he's saying that he is innocent and he's just someone who may have certain proclivities, but that doesn't mean that you are a criminal. I think he's doing the best with what he has. So I'm not ready to throw the baby out with the bathwater with the attorney at this point. Now, do I think that he is going to remain his attorney? I would not be surprised if an entire legal team is brought in to handle this. And by the way, this is not Sean Combs, Diddy, however we want to characterize him. This is not his first attorney on this case, or not necessarily on this case, but on the things that were actually leading up to this case. This is not the same person who has represented him, certainly in the civil matters, which makes sense though, because those were civil cases and this is a criminal one. And apparently this gentleman is you want a specialist who deals with what you're dealing with. So yeah, great question. But I'm not ready to throw the baby out with the bathwater with the attorney yet. However, I do believe, because he has the money and he wants to get out of jail, that he will probably roll his dice with, if not another attorney, he will add to his overall legal team. But I don't know if I think Mr. Anfilo, but how, now I'm screwing up this darn name. How do you say that again? I had it together. I really did. Agnifilo. I don't think that Mr. Agnifilo is going anywhere because Diddy thinks that he did a bad job per se. I think you just got to do what you got to do to get the hell out of jail. And at this point, since he's stuck there, now you got to do what you got to do to put together a team that is capable of moving your case, of trying to make a case that typically takes a long time or could take a long time, where you waive your speedy trial rights to so that you have more time to prepare, what have you. I think this is going to be a situation where part of adding to the team is so that they can get more done quicker to avoid delays, so that whatever that first trial date is that is set, that if everything goes well, that trial date is the one that happens. Because obviously with him not having bond, now he's sitting in Rikers. I can understand why nobody would want that. I don't think he should get any special treatment as it relates to him not being there when everybody else who's charged with a criminal offense is there. But quite frankly, given the conditions at Rikers, nobody should be there. So it's not a Diddy thing. That place is just ridiculous, and any possible thing that you could come up with that's wrong with the prison, Rikers would be would check those boxes. So anyway, that's all we have for tonight. So I hope you learned something. I am probably going to, especially for my podcast folks, I am definitely going to be splitting this live into 2 episodes with a part 1 and part 2, or in this case, I guess a part 2 and 2A. Because yesterday, obviously, we dealt with the indictment and today with the bond. But so you'll get both pieces of that. So if you're watching the live version, then it'll be all of it. But the recorded versions, I'm definitely going to split up because we talked about so much. Now, that is it. Good night, everyone. It has been a long couple of days, and I don't represent any of these people. I actually need to go and do my own work. For those of you who are listening on the podcast, make sure that you like, comment, and subscribe, especially if you are listening on a stream that allows you to do so, particularly Apple and iTunes. Give me all of those stars. Make sure you give me comments. Same thing with my Podbean people. Give me all of those stars and those comments. If you are watching this on YouTube, and I forgot to put it across the bottom, I will definitely have to fix that in post. Make sure that you like, comment, and subscribe. Good night, everyone. I will see you the next time.